When you consider the question of management risk on the Chinese mainland, you have to really also consider the question of contractual disputes. What are the positions of the parties concerned, particularly if they're aggrieved? Adam Hugill from Oldham, Lee and Nye is with us. When it comes down to it, you just have to say, see you in court.
No, see you in court is usually the very last step that anyone should have in any dispute. Most people in day-to-day life are perfectly fine at sorting out their own disputes. The same goes for most commercial disputes. Parties, companies can talk amongst themselves and sort out disputes between themselves. Where parties can't resolve disputes, usually because the amount of money involved is quite high, or there's a lot of complex issues, or perhaps the issues require analysis of the law, then the first step for most people would be to go and see a solicitor. And then solicitors really should try and work, usually a solicitor on either side, to negotiate and to resolve the dispute before it goes to court. Where that doesn't happen, parties often look to courts in the first instance. But since April this year, the civil justice reforms have encouraged parties to explore mediation. And mediation should be something people are looking at prior to litigation rather than as something that happens during litigation. And mediation effectively involves parties getting together with a qualified mediator to resolve the disputes that way.
And when we're talking about this new law, this is the law of Hong Kong.
Yes, it's effectively guidance which will be punished by costs in courts if parties decide not to mediate.
Adam, when considering the dispute, would you be choosing Hong Kong or the Chinese mainland when you're advising your client?
Quite often, the first place to look is in the contract. Most parties, when drafting up a contract, will have as a boilerplate term the jurisdiction. This dispute, if there's a dispute, it will be governed in Hong Kong or it will be governed in the PRC. Where a contract doesn't include a jurisdiction clause, the parties should really look to see where the hub of the dispute is. Where are the parties physically situated? What does the dispute involve? And really, where would be naturally best suited to hear the dispute? Many people, especially international trading organisations, do like the laws of Hong Kong. They're respected worldwide. They're based on an established common law system coming from England and Wales. And so naturally people do prefer to try and litigate using the Hong Kong legal system.
So what advice would you give to clients if you didn't want to go to law but instead wanted to go to arbitration? Would you choose arbitration over law?
Again, look at the contract. Parties often agree to arbitration clauses. If you don't want to go to the court and you've got an arbitration clause in your contract, you can use that against the other side if you like to insist on arbitration. Arbitration itself is something people can agree to, the two parties can agree to without having it written into the contract in advance. The benefit of arbitration is that the person who hears the dispute is an expert in the field. It's not a judge who deals with any number of legal issues. It's usually a technical expert, and the parties can agree on who that is, or indeed, if they wanted a 2 or 3 person panel. The benefit of arbitration is that at the end of the day, the outcome, the decision made by the arbitrators is legally binding and generally enforceable. The other benefits from arbitration is that it's considered quicker and usually easier than going through the courts, and it can be kept confidential.